The National Legislation Council, performing the duty of the Parliament of the Government of the Kingdom of Thailand, has adopted on 28th of February 2019 the Personal Data Protection Act or PDPA and the Cyber Security Act. The laws have been publicized in the Government Gazette on 27th of May 2019. The Cybersecurity Act has already been in effect since from the publication. For the PDPA, it was supposed to become effective 1 year after publication, i.e. 27th of May 2020, but the enforcement date has been announced later to be extended to the 1st of June 2021. These are the two major legislation developments in Thailand. Let me touch a bit upon about the PDPA. Personal data has been defined as any information which can identify a natural person directly or indirectly, but excluding information about a dead person. Now, let's have a look into the scope of application of the PDPA under Article 5. According to Article 5, any collection, use, or disclosure of personal data by controllers or processors who are in the Kingdom of Thailand, whether the processing takes place in the Kingdom of Thailand or not, shall be subject to the PDPA. Or, in case the data controllers or processors are outside the Kingdom of Thailand, the processing of personal data of data subjects who are in the Kingdom of Thailand, where the processing activities are related to a. The offering of goods or services, irrespective of whether a payment of the data subject is required to such data subjects in the kingdom, or the monitoring of their behavior as far as their behavior takes place within the Kingdom of Thailand. There are certain activities that are exempted from the application of the law. For example, for personal purpose or personal household activities, for those competent authorities in charge of safeguarding against and the prevention of threats to public security, safety of citizens, money laundering prevention and suppression, forensic scientists, cybersecurity, for mass communication, art, literature, according to ethical practice or public interest, for the use by the House of Representatives, Senate, and the committees, for the court procedures and competent officials, for the tasks carried out by the credit bureau and members according to credit business law. Lawfulness for processing of personal data under Article 19. The basic legal basis for processing of personal data is consent. Consent could be given in writing or by electronic means, or in case that the writing or electronic means could not be performed, consent could be in the other form. The consent to be given must be clear affirmative act, specific, unambiguous indication, if freely given, must be informed, and last but not least, must be easy to be withdrawn. Apart from the consent, there are some other legal bases for processing of personal data. For example, for making a historical document, for the study, for research or statistics, for protect the vital interests of the data subject, or for performance of a contract, or for tasks carried out in the public interest, or for legitimate interest pursued by the controller or by a third party, or for compliance with a legal obligation. Rights of data subject. Data subject has certain rights to exercise for his or her own data. For example, right to be informed of information when personal data are obtained from the data subject. Right to be informed of information when personal data are not obtained from the data subject. Right of access, right to rectification, right to erasure or right to be forgotten, right to restrict or processing, right to data portability, right to object. But there is one right which is mentioned in the GDPR but is not mentioned in the PDPA. It's the right not to be subject to a decision based solely on automated processing, including profiling, which produce legal effects. Apart from the data subject, the PDPA sets and divides person into two groups, controller and possessor. While controller is a natural or legal person which determines the purpose and means of processing of personal data. A processor means a natural or legal person which process personal data on behalf of the controller. So both controller and possessor have a common role and responsibilities. So when a controller wants a possessor to process the information on his behalf, there must be a processing agreement entered into between controller and possessor. They have to maintain the record of processing activities. They both have to designate a data protection officer or DPO if required. They have to cooperate with the supervisory authority and also need to implement appropriate technical and organizational measures and to designate a representative in the Kingdom of Thailand. And they have to comply with conditions for transfer of data to third country or international organizations. In case of breach, a data processor shall have to notify the breach to the controller without delay, and the data controller shall have to notify the authority or the committee within 72 hours. So those are roles and responsibilities of data controller and data processors. Conditions applicable to child's and inability persons' consent. The processing of some types of the personal data of a child, where a child cannot perform by himself, shall be lawful only if and to the extent the consent is given or authorized by the holder of parental responsibility over the child. However, in all cases, if the child is below the age of 10 years, such processing shall be lawful only if and to the extent that consent is given or authorized by the holder of parental responsibility over the child. In case of inability persons, consent must be obtained from the guardian. Notification of a personal data breach to the supervisory authority. So when there is a breach in personal data, the data controller shall have, without undue delay and when feasible, not later than 72 hours after having become aware of it. Notify the breach to the supervisory authority. But when the personal data breach is likely to result in a high risk to the rights and freedoms of natural persons, the controller shall communicate the personal data breach and remedy action to the data subject without undue delay. However, the breach notification procedures shall be as announced by the committee. Transfer of personal data to third countries or international organizations. When transferring of personal data to third countries or international organizations, the following measures shall have to be taken into account. Adequacy decision or adequate level of protection. The destination of data must be in adequate countries or international organization to ensure an adequate level of protection according to the conditions announced by the committee. So in case of doubt about adequacy level, could be submitted to the committee to consider. Appropriate safeguards. Measures such as binding code of conduct or corporate rules or measure as approved by the supervisory authority. Derogation of specific situation. The data subject has explicit consent to the proposed transfer after having been informed of the possible risks of such transfer due to the absence of adequacy decision and appropriate safeguards, or necessary for the performance of a contract between the data subject and the controller, or the implementation of pre-contractual measures taken at the data subject's request. Necessary for conclusion or performance of a contract concluded in the interest of the data subject between the controller and another natural legal person. Necessary in order to protect the vital interests of the data subject or of the other persons where the data subject is physically or legally incapable of giving consent, or necessary for important reasons of public interest. Under GDPR, the term processing is clearly defined and specific to certain activities from item to item. But under the Thai PDPA term processing, the express the meaning in a collective way and referring to the collection, use, and disclosure of personal data. For the comparison of the data subject rights, as discussed before, only the right not to be subject to automated decision-making provided in the GDPR is not provided in the Thai PDPA. For the penalty, the GDPR provides for the administrative fine up to 20 million euro, or in the case of an undertaking, up to 4% of the total worldwide annual turnover of the preceding financial year, whichever is higher. Under the Thai PDPA, however, not only the administrative fine is provided, there still be other penalties, both criminal and also the damaged person could pursue the civil case for compensation as well. Let's have a look into the criminal penalty under the Thai PDPA. Imprisonment maximum of 6 months or a fine maximum of 500,000 Thai baht or both. So this applies for the case of not obtaining consent when required or transfer sensitive data to non-adequate destination or disclosure of personal data known from duty, of imprisonment of 1 year at maximum or a fine of 1 million baht at maximum or both. So if special intent or if done with interest involved. In case of juristic persons, if done with command or act of directors or managers, same penalties shall apply. The administrative fine of maximum of 1 million Thai baht could be imposed by the supervisory authority if the controller or the processor do not inform proposed direct or indirect collection of data, do not respond a data subject right exercise within 30 days, do not record processing activities, do not designate the DPO when required, do not support the DPO, or dismiss the DPO with undue reasons, or request for consent is unclear or do not separate or not free, or do not inform impact of consent withdrawal, or the representative of controller or processor does not record processing activities or does not designate the DPO if required. The administrative fine of maximum of 3 million Thai baht could involve severe inappropriate processing of personal data. For example, collection, use, or disclose data for other purposes than consented. Collect data exceeds the necessity. Collect data without consent. Collect indirect data without information. Use or disclose data without consent. Transfer of data to non-adequate destinations. Collect, use, or disclose of data with objection, or do not apply security measures, do not take measures to delete data when expired or requested. Consent with unclear objective. Do not inform data subject within 30 days when data collected indirectly, or improper transfer of data to third country or organization, or processor does not perform duty as contracted, or does not apply security measures, or does not record processing activities. Admin fine of maximum 5 million Thai baht. This could involve collection, use, or disclosure of sensitive data without explicit consent or due reasons, or improper transfer of sensitive data to third countries or organizations. Prior data collected under the GDPR, the consent obtained prior to the effective date of the GDPR, if not follow the rules and procedure as set forth in the GDPR, the data controller or data processor may need to get a new consent if required. But under the Thai PDPA, prior consent obtained can be used further according to the original purposes, but data controller must provide the easy channel for the consent to be cancelled. Thanks for watching. If you like my video or if you want to hear more about the Thai PDPA, just write to me in the comments box below. Thank you and goodbye. สวัสดีครับ